I'm going to go ahead and get started. My name is Scott Horton. I'm an attorney with Horton Law, which I founded in April of 2017 after more than a decade with a larger law firm practicing labor and employment law. I represent employer organizations ranging from private companies, nonprofit, to governmental entities, villages, municipalities, school districts, and the like. Pretty much any organization that has employees, most typically in New York, I am able to assist with various matters, much beyond what we're talking about today. But what we are talking about today is a very important topic for all employers. And in particular, we're going to focus on New York employees because that gives us an opportunity to really dive into some comparisons and distinctions between the federal overtime law and the New York State overtime requirements. Again, the slides will be available at the end, and I am planning to go about an hour until around 1 o'clock. But at the end, we'll be doing question and answer, and I will stay around to make sure that I answer all the questions that I can. So if we go a little over and you're able to stay, that's great. But let's get going. Here's an overview of where we're going. We really have a lot to cover. I will warn you now that some of the slides have a lot of words on them. That's not my typical approach to presentations, but there is a lot of detail on some of these issues that I wanted to make available to you. So again, you'll have that when you get a copy of the slides, but I won't necessarily read every word on all of those slides as we're going through this. The two sources of law that we're going to be balancing and tackling today are the Federal Fair Labor Standards Act, commonly known as the FLSA. This is a law that has been around at the national level for many decades and set the minimum wage and overtime requirements for many employers across the United States. The New York laws that are involved, it's really the New York labor law and then minimum wage orders that are promulgated by the New York Department of Labor. There are several minimum wage orders. The minimum wage order for the miscellaneous industries is the one that pertains to most employers. There's also a hospitality industry wage order that applies to a number of employers that have hotels and restaurants. I'm going to do my best to synthesize all of the New York requirements, and I won't always specify exactly what the source of the requirement is. So if you have a specific question about that, then feel free to ask. What we're mostly going to be focusing on is the so-called white collar exemptions, because these are the exemptions that are most broadly applicable in the workplaces. There are various other exemptions that apply to limited numbers of employers and employees, and I will mention some of those. They're pretty limited in who they apply to, and if they apply to your business, hopefully you're already aware of that. But if not, and you think there might be something that applies, it just gives you an idea that you should go looking for that and pin it down. And then finally, we're going to discuss I skipped the salary requirements. So there are salary requirements for some, but not all of the exemptions. We'll go into detail on that and finally discuss changes. And the most recent changes to both federal and state law come in the area of the salary requirements, including proposed and in fact initially adopted rule change under the Fair Labor Standards Act that would have changed the salary threshold for certain exemptions, but did not end up taking effect because of courts and then a change in the administration in Washington. So we'll talk about the status of some of those issues and what might yet be changing in the future. All right, again, the FLSA is the Fair Labor Standards Act, the federal law that applies to employees and employers throughout the United States. It is applicable generally based on two tests, the enterprise coverage and individual coverage tests. You really don't need to get too far in the weeds here. It's safe to assume in most instances that the FLSA covers your workplace and your employees, but just so you have the background in case for some reason you're on the border. The enterprise coverage means that the business organization is covered if it has at least 2 employees and either does at least $500,000 in revenue a year, or even if less than that, is a hospital, business providing medical or nursing care for residents, a school or preschool, or a government agency. So certainly there are some small businesses that don't have $500,000 in revenue and don't fall into one of those particular categories. If that's the case for your organization, you also need to consider the possibility of individual coverage. And this means even in a business that's not covered under the enterprise coverage, if an individual employee works in a manner that involves them in interstate commerce, then they would be protected by the Fair Labor Standards Act. And it's a pretty light burden to show that you're an employee in interstate commerce. You just have to either produce goods that will be sent out of state, regularly make phone calls, or probably these days send email or otherwise communicate with persons out of state in the course of the business. If you handle records of interstate transactions, or if you travel to other states in the course of employment, then you'd be covered under the individual coverage, even if the business isn't covered. So that could apply even to a small company with revenues under $500,000 with only 1 employee, for example. That employee may be covered by the FLSA. Let me note at this point too that business owners often are not covered, even though they may be employees. They may receive a salary or wages. They may even receive W-2s from the business entity. So if you're faced with whether or not a business owner is exempt, you may not need to refer to these exemptions. There may be just a more general principle that excludes them from being considered an employee. They're more likely to be considered the employer. But if you have employees, for example, in an employee stock ownership program that just own, a really small amount of stock, a few percent or so of stock in the company, that's not going to exclude them from coverage. The New York law is going to apply to most employers in New York State, as well as the FLSA. So many employers in New York State have to make sure they're satisfying both the FLSA and New York law, and that's something we're going to come back to a few times throughout this presentation. But the New York minimum wage and overtime requirements generally apply to all New York private non-governmental employers, including both for-profit and not-for-profit organizations. And on the public employer side, it does apply to non-instructional employees of public schools. So villages, towns, counties, cities, some public agencies are likely not subject to New York's minimum wage and overtime requirements, but they are subject to the FLSA, again, unless some particular exception or exemption applies. But for whatever reason, peculiarly, public schools, they're non-instructional employees, so people other than teachers and academic administrators are subject to the state minimum wage and overtime requirements. We're not going to talk too much about minimum wage here. These exemptions we're talking about generally would exempt somebody from both minimum wage and overtime. In most cases, anybody who's going to be exempt is also going to receive at least the minimum wage. But if they are exempt, then that almost always would mean that they don't have to receive even minimum wage, as long as they can otherwise meet the exemption tests. The main white collar exemptions, or really the white collar exemptions, are the 6 that are on this slide. We're going to go through each of these. The sort of EAP exemptions on the top line, your executive, administrative, and professional exemptions. These are the most commonly applied and commonly applicable exemptions from overtime at both the federal and state level. Both the FLSA and New York law recognize all 3 of those exemptions. They're relatively similar in each case, but there are some subtle differences that can make a difference. The outside sales exemption is also available at both the state and federal level and is nearly identical at the 2 different levels. There's a computer employee exemption under the FLSA that isn't paralleled under New York law. We'll talk about what that might mean. And then there is a highly compensated employee exemption under the FLSA that is sort of a relaxed test for employees who make total compensation at a particularly high level over the course of a year. The highly compensated employee exemption is also an FLSA only exemption. It's not specifically included in the New York laws. But again, it's likely that most, maybe in some cases, virtually all employees who qualify for the FLSA highly compensated employee exemption would also be exempt under one of these other tests that would apply even at the state level. Just before we break down these common exemptions, the FLSA has a number of various exemptions that apply in particular circumstances and particular types of workplaces. Here's a few on the slide of probably the most common of these relatively uncommon exemptions. So there's exemptions and special rules for agricultural employees, people that work on a farm, for example, and there's that at the New York level as well. I don't know that we have anybody here who works involving agricultural employees at the farm level, but if you do, you might have some special parameters, but some of these principles are still going to apply even in that case. The next one here, employees paid commissions by retail establishments. That does happen, especially at some higher end retail establishments still. So there's special rules there. There's a motor carrier exemption for certain transportation companies. Newspaper and other communications workers includes some really narrow types of employees for newspapers and small radio stations, for example. And then seasonal amusement or recreational establishments. So if you have an amusement or recreational establishment that's only open part of the year, there are some special rules and exemptions there too. But again, these are not very widely applicable, but I just want to let you know these are the types of things that might be out there, and there are some others. So if by chance you're in a peculiar industry, then you might not peculiar in a bad way, but just peculiar with respect to the FLSA, then you might have slightly different things to consider. So for most of these white collar exemptions, we're talking about 3 components to the exemption. There's the duty tests based on what the employee actually does, and then there's both a salary basis and salary level requirement. So some of the tests require that some of the exemptions require that all 3 tests be satisfied. In other words, that the employee perform the right duties, that they are paid on a salary basis and that their salary is sufficiently high. Some of the exemptions don't have each of those requirements, and we'll talk about that. Again, I'm not going to go through all the words on this slide. The main take-home point is that there's really no exemption that applies solely based on salary. The closest would be the highly compensated employee exemption, but as you'll see when we get there, there is still a duty component even of that exemption. This is one of the most common misclassification mistakes that employers make, is to just say, well, this employee is paid a salary. Maybe they then look to find out whether it is a high enough salary under the applicable salary level requirements, and then they say, okay, so they're exempt. But it's very important to make sure that the employee also satisfies the applicable duties requirements. So salary basis generally means that the employee has to be paid a sufficient salary weekly, and there are some caveats on making deductions from that salary. In other words, if an employee has a regular salary of $1,000 a week and doesn't show up one day, usually the employer can't just say, well, we're going to dock your pay because you're only working 4 days this week instead of 5, so we're going to pay you $800 instead of $1,000. But there are some cases where the employer can make deductions without upsetting the salary basis requirement, and they usually require leaves of at least a full day. So, an employee who just takes an hour off here and there, leaves early, starts late or whatever, typically can't have their salary reduced as a result. But if you have a bona fide plan of providing sick leave to employees, and your employee who happens to be salaried runs out of time there and then has to take off 1 or more full days, you could make a deduction as a means of having your sick leave policy actually be viable, and not just something that's on paper but doesn't have any impact, at least on exempt employees. But again, you do have to have a bona fide plan, policy, or practice in place. Bona fide is the word that basically is used in the law, so you have to really look at that. It can't just be something that you apply sometimes, but not always. If somebody takes a personal day for a reason other than sickness or disability and you don't have personal time available, then you could potentially deduct from their salary, but be careful how you do that and don't do it in a discriminatory manner. A couple other things on this list. They do include disciplinary suspensions. So if you do suspend an exempt salaried employee for a few days, for example, then you don't necessarily have to pay them for that time. Also at the bottom of the slide, I just note, and this I think most people would understand, that the employer is not required to pay a full salary in the first or last week of employment. So if somebody starts on Friday and they happen to be salaried, you don't have to pay them their full salary for that work week if it ends on Friday or Saturday or whatever. You can prorate it just as you can the last day. People can't quit on Monday and expect to get paid for the full week. And then the FMLA, which provides unpaid leave in some circumstances. If an employee takes time off for FMLA, they can have their pay reduced without violating the salary basis. But again, you have to consider what your other policies and benefits would be. In New York, we now have the new paid family leave to consider, and that might interact. But if it is unpaid FMLA leave, then it can lead to a pro rata deduction in the salary. Why is all this so important? Why am I putting this in here? Because improper deductions could not only ruin the exemption of the one employee for whom they're made, but in some cases it could potentially even result in all of the employees in the same job classification losing the exemption. So if you have 7 people in your accounting department who do similar exempt work, and one of them loses salary improperly over a period of time, for example, then the Department of Labor or the court could ultimately rule that not only did that person lose exemption and become eligible for overtime, but everyone else in the department also was entitled to overtime. There is a safe harbor under the FLSA to address this issue. Basically, if the employer has a policy in place that's known to employees, or at least knowable to employees, if it's in your employee handbook and employees get the employee handbook, that's probably sufficient. Whether they've actually read it or not is probably not critical, but it can't just be something in an internal policy manual that nobody ever sees. So they have to have a policy in place about what happens if there's an improper deduction, and the employer then, if a complaint is made, actually reimburses the employee and then makes a good faith commitment to comply in the future, which would presumably mean, finding out why the mistake was made and taking some action to avoid it going forward. Then the exemption won't be lost unless there's evidence that the company, willfully violated the policy or continued to make improper deductions despite knowing about the problem. All right, so that's the salary basis requirement. People don't spend too much time on that. They get right to the numbers, which admittedly the numbers are the easiest part of these exemptions to evaluate in most cases. So let's go ahead and get to the numbers. So this chart kind of shows the changes in the FLSA salary level requirement for the overtime exemptions. I'm lumping it all together. There's a slight bit of variation in some cases, at least historically, between the different exemptions, but this is the standard salary level that most generally applies and has applied over these time periods. So from 1975 to 2004, so almost 30 years, for practical purposes, the requirement was $250 a week. That was changed in 2004. The duties tests were changed in some regards at that point as well to increase to $455 per week. And that's where it stayed until 2016. 2016 is when the Department of Labor, then in the Obama administration, put a new rule into place that would have more than doubled the weekly salary requirement to $913 per week. It also established an automatic indexing of that $913 a week, so that every 3 years it would change. This is the way the rule was written, but as a practical matter, it was almost guaranteed to increase based on a measure of the average salary of exempt employee, or the average salary of salaried exempt employees in the southern region of the United States, which is the lowest earning region. Theory being there that if you balance it based on the lowest earning region, whichever that is at that point in time, then at least you won't be having a disproportionate negative impact on the more economically challenged parts of the country. So the Northeast, for example, wouldn't be the right measuring stick to apply across the whole country, because they tend to make, salaried employees there tend to make a lot more money. Okay, but we came really close to having that $913 a week requirement take effect. Within weeks of having it take effect, actually, before a federal judge in Texas imposed an injunction saying, no, I'm not convinced that the Department of Labor had the authority to increase the salary requirement that much. He actually said he wasn't sure whether they had the right to set a salary requirement at all, but at least in this case, whether they could double it basically overnight, much less than establish automatic indexing increases every 3 years. That case technically remains on appeal, but when the Obama administration took over, there was a change in the makeup of the higher ups in the Department of Labor, and they tended to be more pro-employer, or at least that's what everybody would assume. So it wasn't surprising that they made it clear that they weren't going to try to implement that 2016 rule. They're only the appeal is only pending because the Department of Labor wants to be able to maintain that it at least has the right to establish a salary level. So they kind of are leaving open the possibility of contesting the judge's view that maybe they didn't have the right to set a salary level in the first place. But the Department of Labor has also issued a request for information in the middle part of last year that suggests that they'll probably end up implementing their own new rule under the current administration, but we don't yet know what that's going to look like. Nevertheless, we'll come back and talk about that a little more later on. Okay, so the result of that all means that at the federal level, we never actually moved from that $455 a week requirement. So now I'm going to put up a poll. I'm just curious if you don't mind clicking a button for me. I'm just going to ask how many of you, if you know, in your organization had changes made in anticipation of that new $913 threshold. So when you see the poll pop up, if you can just click yes or no, or I don't know, it would just be interesting to have this quick survey. Looks like about half and half between yes or no, and then some people don't know. We're fading to where no is a little more popular. But so clearly some of you did have changes in your organization based on this new requirement, or what we thought was going to be the new requirement. Then I just want to ask as a follow-up, how many organizations changed back after the $913 a week standard was, reversed or stopped? So here's that poll. So if you were in the camp before where you never made changes in the first place, then you can just say no. Just choose one of the yeses if you had made changes. So far nobody is saying that they changed back once the rule was struck down. Okay, I think there are some employers that did make that change, but I'm not surprised in a group of this size that nobody did change back. So that's certainly possible, and that was the easiest approach. Although I had some employers that I was aware of that had to make changes, changing people from exempt to non-exempt, which the employees didn't really appreciate. So I think in that type of situation, the employees and the employer were relieved that they were able to go back to having those employees be exempt. Now, that was a situation where they didn't increase the salary to meet the $913 a week. Rather, they just changed the exemption status and then we're able to change it back. All right, and here's another reason why it may not have affected as many employers in New York as it may have in other parts of the country. The New York salary level for the state level exemptions was already higher in many cases, well, actually probably in all cases at this point, than the $455 level, federal level. This shows now the current and then planned future salary levels for the New York exemptions. Around the time that the federal level was increasing to $913 per week, the state increased its minimum wage and then the exemption levels as well. But for the first time, or at least the first time in recent history, broke the requirements for both minimum wage and the overtime thresholds out based primarily on geography, what part of the state the employees work in, and then in the case of New York City, also the size of the employers. So for New York City employers with 11 or more employees, the minimum wage has jumped the highest already to where by the end of this year, it will get up to $1,125 per week, which is obviously considerably higher than the $455 federal requirement and even considerably higher than the proposed $913 federal requirement. The next highest chart is the New York City employees with New York City employers with fewer employees, but again, you see, it just takes an extra year to get up to that $1,125 threshold. The Long Island, that's I believe Suffolk and Nassau counties and Westchester County table is the next highest level, and then the rest of the state, other than those, I think it's 4 counties, upstate, Western New York, Southern Tier, all the ways you want to break it down are on this first table on this chart. So the current exemption requirement is $780. That increased on December 31st, 2017. Not sure that the most logical thing to have these increases take effect on the last day of the year rather than the first day of the year, but that's what the state has done. The schedule, as you can see, for the rest of New York State currently is only established through December 31st of 2020 when it jumps to $937.50. It seems likely that the intent is to ultimately increase it up to that $1,125 level, but I think the economics of the rest of the state compared to those 4 downstate counties are so disproportionate that they couldn't or didn't feel that they could forecast it out that far. And these levels are really based on the minimum wage. So this isn't what the legislators and policymakers are looking at in Albany directly. They're looking at the minimum wage, and it's the question of when and how you get to the $15 minimum wage, for example, that drives this. I didn't show, but there was an increase on December 31st of 2016 too. For example, these weren't the first increases. I just want to do one more of these quick polls right now and just see how many of you were aware that these salary requirements in New York went up on December 31st. So when you see that poll come up, just simple yes or no. So it's probably a good thing. The majority of you look like you are aware. Maybe 2/3 were aware of this, maybe a little more. So, it may be that others of you didn't need to be aware because the change didn't affect anyone in the organization that you work in, or maybe it's not your responsibility to worry about that thing at this point in your time in your organization. But now you're aware of it, and you are aware that there will be more changes in the coming years. I just throw in it's certainly possible that these numbers will change just because we have tables for the next few years in these different parts of the state. If there's reason to increase the minimum wage, it could change, and it's possible that the federal level will change, and then that will cause the state to want to make some sort of corresponding adjustment. I think foreseeable future is likely that any New York State adjustment would be up, and whether that will occur before the end of these tables remains to be seen. All right, so that's really most of the time we're going to spend on the numbers, on the salary requirements. And again, in basically no situation is the salary the only question. You also need to consider the duties of the employee, and specifically what the employee actually does, not just what a job description says the employee is supposed to do. So we'll start with the EAP exemptions, executive, administrative, and professional. These are the most commonly considered exemptions for many of your employees who could possibly be exempt. The executive exemption, the reason I use this picture, does not necessarily mean that the employee is an executive of the organization. I'm not sure why this woman is wearing a hard hat in a shoe store or clothing store, whatever it is, but I think the idea here would be that, you know, she could well be a foreman or manager that works in construction, for example, and she could very well be exempt under the executive exemption, even though she's not a vice president wearing a suit and reporting to an office every day. So what is the executive exemption? I have slides on both the FLSA and the New York State executive exemptions. They're very similar. Some of the words don't match up exactly, so I have them both for you. The executive exemption does require the salary or fee basis of at least $455 per week. Again, I just asterisk that because that was the number that was supposed to go up to 913 but didn't. So at the FLSA level, it's still at $455 for now. Just in case you're wondering, the fee basis compared to salary would be a situation where somebody gets paid, for example, by the job. So if your job is to oversee construction of a house, for example, and you get paid a certain amount per house, that can be calculated into a weekly salary, even though you might not actually get paid each week. But most people are paid on a salary basis. A fee basis generally wouldn't mean a commission. It's a different animal altogether, but there would be some similar approach. But if someone is just paid on a commission basis, then that would not meet the salary requirement. They could be paid on a salary plus commission basis, for example, or they could receive bonuses. But at this point, these exemptions require an actual salary of at least the $455 per week. That was one of the components of the 2016 rule, that you could use up to 10% of non-discretionary additional compensation like commissions or bonuses, but that change also has not taken effect. The primary duty has to be management of the enterprise or a customarily recognized department of it. The customarily recognized department or subdivision is intended to distinguish between just a collection of employees assigned to a specific job. and units with permanent status and function. So if you're just working on a project and you're pulling some people together and so manages the project, that wouldn't necessarily qualify you for the executive exemption. It's more, if you're the head of this team that regularly handles all of those types of projects, for example, or if you're the, manager of a recognized division or department. If they customarily and regularly direct the work of 2 or more other employees, it's actually 2 or more full-time equivalents. So it could be 4 half-time employees to trigger the exemption. So if you have somebody who manages a department, but they only oversee 1 employee, then the executive exemption is not going to be for them. In some companies, that's why the executive exemption wouldn't necessarily apply to all of the executives. So it might be the vice president of sales, for example, but if there's only 1 other salesperson that they oversee, you'd need to look for a different exemption, which you may well find. And again, because of the management notion, the person has to have the authority to hire or fire other employees, or their suggestions and recommendations to doing so would be given particular weight within the organization. So it can't just be that, you're the person, or this employee is the person that somebody reports to every day and they hand them the assignment and then they go off and do whatever they're going to do. They have to be more involved with the actual status of the employee. For example, doing their performance reviews would be one indication, even if maybe they don't quite get to the level of doing the hiring and firing directly themselves. All right, we spent time there, so I could just basically say the New York exemption works out about the same. Again, you have to manage a division or the enterprise itself or division thereof. You have to direct the work of 2 or more other employees. Similar requirement for authority to hire, promote, advance, or fire the employees. There's also this component of regularly exercising discretionary powers, which isn't specifically included in the federal executive exemption, but wouldn't be unusual to find in people that qualify for the federal executive exemption. And they have to receive a sufficient weekly salary. I can't put a number on this because it's now different depending on what part of the state the person is in, and it will be changing from year to year, as we showed a couple slides ago. All right, let's move to the administrative exemption. Some people have, over the years, improperly associated the administrative exemption with administrative assistants. There are some administrative assistants who can be exempt under the administrative exemption, but that's actually pretty unusual. The administrative exemption is more likely to apply to maybe those executive employees who don't have enough direct report to qualify under the executive exemption, as well as to people who are not managers but have roles of sufficient business responsibility in areas like tax, finance, accounting, budgeting, marketing, insurance, quality control, purchasing, marketing, human resources, labor relations, public relations, those different types of core components of a business. You'll see on the slide for the FLSA administrative exemption that the primary work has to be of an office or non-manual nature. That's not to say that the employees can't do some physical work or might not be working with their hands from time to time, but the primary duty has to be office or non-manual work. Primary duty meaning the principal, main, major, most important duty that the employee performs. Again, you have to meet the salary requirement, and here the work also has to include the exercise of discretion and independent judgment with respect to matters of significance. So it can't just be that you work in an office, and that's why an administrative assistant isn't necessarily exempt under this requirement merely because he or she is paid a sufficient salary. They also have to be doing something where they exercise discretion and independent judgment with respect to matters of significance. The exercise of discretion and independent judgment involves the comparison and evaluation of possible courses of conduct and acting or making a decision after the various possibilities have been considered. So again, there are some executive assistants, for example, who have enough discretion and independent judgment to qualify, but the average receptionist, for example, probably would not. So again, it's more the core business areas and people at at least a managerial or director type of level usually would be the ones that would satisfy the administrative exemption. Here is the New York wording, but again, essentially the same, except there's this added component of regularly and directly assisting the employer or an executive employee or performing under only general supervision work along technical or specialized lines that require special training, experience, or knowledge. Again, this is really another way of emphasizing the importance of what the person is doing and not just that they're doing some routine office tasks. Then we get to the professional exemption, and this is the exemption that really does most clearly match its name. It's certain forms of quote-unquote professional categories of employees. Not to say that there aren't other employees who certainly behave in a professional manner and have professional responsibilities, but these are the real traditional professions that usually qualify for this category of exemptions. There's really two subcategories of the professional exemption under both federal and state law. The learned professional exemption, which you can see the wording there. The FLSA in New York get at it a little differently, but essentially you have to have advanced knowledge in a type of science or field of learning where a long course of specialized intellectual instruction, i.e. schooling, is normally required. That doesn't mean that you necessarily have to have a degree or have to have gone to school and gotten the degree. It just means that most people who have that job have gotten a certification or advanced degree or something of the like. So for example, lawyers are going to qualify as professionals if they're doing real lawyer work. And almost all lawyers today, at least in the United States, go to law school, but technically in most states you don't have to go to law school to become a lawyer. If you can otherwise qualify and pass the bar and be certified to practice law, then you can qualify under this requirement. Likewise, some engineers wouldn't necessarily have to study engineering in school. If they have developed the same skills elsewhere, they could still qualify for this exemption. There's another quick question. Will the presentation be available to print? Yes, at the end I will be giving out the slides. Yeah, that's why I put so much on the slides so that you can print it and have it for future reference. Here's just some more information along those lines, just breaking down what pretty much I just said. The New York exemption does add a little bit, requiring the exercise of discretion and judgment, for example, but when you combine the requirements together, they more or less get at the same types of things. Then there's the creative professional exemption. And this one requires invention, imagination, originality, or talent in a recognized field of artistic or creative endeavor. Again, the words are a little different, but clearly the New York law borrowed from the FLSA and just used some different words. The FLSA wording has probably changed over time a little as well. So here we're really talking about the fields of music, writing, acting, graphic arts, that type of thing. The people that are going to meet the requirements are usually actors, musicians, composers, some painters, writers, novelists, for example. Some journalists, there's kind of a split among journalists. I mean, if you're writing really intense analytical pieces of journalism, then you may qualify as a creative professional. If you're just basically reporting data and facts that could be, found in a database somewhere, and you're just writing them in an article and putting it in a newspaper, that's not necessarily enough to qualify for the creative professional exemption. On the professional exemptions, under the FLSA, we haven't addressed the salary component. The FLSA professional exemption generally does have the same salary requirement, the $455 per week, but there is no FLSA salary requirement for doctors, lawyers, or teachers, as long as they're actually working in those capacities. Just because someone has a law degree, if they're just doing manual labor for your company, they're not going to qualify for the professional exemption, regardless of whether you pay them a salary or whatnot. But people actually doing this work, you don't have to pay a salary to meet the exemption under the FLSA, which means you also don't have to even pay them minimum wage, technically, because the exemption exempts them both from overtime and the minimum wage. There's also no salary requirement for New York's professional exemption. And that's across the board. So it's not just doctors, lawyers, and teachers. Anyone who qualifies as a professional in New York under the exemption rules is exempt regardless of whether and how you pay them. But in most cases, you still have to be able to satisfy the FLSA salary requirement. So this is one situation where technically the FLSA salary level is higher than the New York salary level because $455 is greater than zero. If you're talking about a doctor, lawyer, or teacher, of course, then it's the same. It's theoretically zero in both cases. This doesn't really matter in most cases because usually people who qualify as a professional are getting paid more than $455 a week anyway. But just so you know, there are those two different requirements at the federal and state level. And assuming you're subject to both laws, then you'd have to satisfy both. All right, we have a couple more exemptions to get through. These are less common and easier to describe because they apply to more specific categories of employees. The outside sales exemption, importantly, does not automatically apply just because somebody walks outside to make a sale. Rather, they must make sales, obtain orders or contract for services, or the like, and be customarily and regularly engaged away from the employer's place or places of business. The New York requirement is worded differently, is basically the same, but it does say customarily and predominantly engaged away from premises instead of customarily and regularly. I'm not sure that makes a big deal. It does matter that the sales occur and that they be outside. Outside here meaning the employee must travel to customers, usually at their places of business or homes, although if they were always meeting people, at a conference center or, at a restaurant or something, then that would apply too, or that would work too. Selling solely by phone, mail, or over the internet does not qualify as outside sales. So if you have somebody sitting in an office, and even if it's their home office and selling over the phone, this is not the exemption for them. If they're at a high enough level, they might qualify at the executive or administrative exemption, but not the outside sales exemption. Sales is relatively broadly defined. It even includes, in some cases, the promotional work that someone does in relation to their own sales. I mean, if you have somebody who sells by setting up a booth at, a conference, for example, then the fact that they might spend the majority of their time working that table is not going to necessarily undermine the exemption. When the outside sales exemption duties are met, there is no salary requirement. Often, these types of employees, at least historically, would have been paid on a commission basis. That's fine. They could be paid hourly. They could be paid on a salary if you want. But they also don't have to be paid. And of course, they don't actually have to complete any sales to qualify for the exemption. That's just what they have to be trying to do. There's a computer employee exemption. And this exemption and the last one we're going to get to are FLSA only exemptions. So these are not specifically recognized in New York state law. Let me just go back. There's a lot of words. The gist of it is, if you have an employee who does something like what is on the laptop screen on this slide, or understands what that means in the course of their work, then there's a decent chance that they might be eligible for the computer employee exemption. The biggest wrinkle in the computer employee exemption, many of these employees might qualify for the professional exemption anyway under the FLSA or under New York law, but under the FLSA, they could satisfy the exemption even if they're not paid on a salary basis, if they're paid on an hourly basis at a rate of at least $27.63 an hour. I think that's a recognition of the nature of the work, and that you might have more part-time people working doing some programming for your business, or at least historically, and maybe still in places like Silicon Valley, this would potentially be a bigger issue. But basically, they have to be computer programmers, software designers, systems analysts, and those types of positions. So again, there's no New York complement, but it's possible that someone would qualify under the New York professional exemption, in which case they wouldn't need to be paid on a salary basis anyway. So the fact that there's no separate hourly test wouldn't necessarily matter. All right, again, the last exemption is a FLSA only exemption for highly compensated employees. This little guy here, and honesty, probably doesn't make enough money to qualify, but for his sake and his parents, I hope that one day he will. The highly compensated employee exemption is available for employees who make at least $100,000 a year in total compensation, which includes at least $455 per week paid on a salary basis. If that's the case and their primary duty involves something other than involves office or non-manual work, then they can become exempt as long as they do at least one of the exempt duties, even if they don't fully meet any of the tests of the executive, administrative, or professional employee exemption. In most cases, somebody who's getting paid over $100,000 in a year is going to meet one of those tests, but just in case they don't, there's this other form of exemption. Under the 2016 rule, the $100,000 level would have increased to $134,000 per year. But again, that didn't take effect, so it's still $100,000 at this point. Just a couple final points here to bring this all together, and then I'll take questions. Thanks for bearing with me. We're running a couple minutes late. It's important to know, based on everything I just told you, because there are some slight differences and disconnects between the federal and New York exemptions, that the New York overtime rate is set as follows. If no FLSA exemption applies for whatever reason, then an employee who is not exempt under New York law would need to get paid overtime at 1.5 times their regular rate, which is the same as the overtime requirement under the FLSA generally. Regular rate might be their hourly rate, might be some pro rata portion of their salary, and might include some other pieces. It's a little beyond this presentation. But the important part is if somebody is not exempt under New York law, but is exempt under the FLSA, then the New York overtime requirement is generally 1.5 times the New York minimum wage. In basically every case, if you're doing it right, the New York minimum wage is going to be less than or equal to the regular rate. So what does that mean? If somebody is not exempt under New York law, but would be exempt under the FLSA, you don't have to pay them at the full overtime rate to satisfy New York's overtime requirement. This is generally true for most New York employees, but double check to make sure if you're going to rely on it to pay a lower overtime rate for somebody who's exempt under the FLSA but not New York law. The hospitality industry minimum wage order, for example, probably doesn't make this same distinction, so you may still have to pay 1.5 times the regular rate, even if an employee in a hotel or restaurant, for example, would qualify for an FLSA exemption but not a New York exemption. That's a pretty complicated point, but I wanted to put it out there in case it comes up. And now I just want to wrap up by talking about what changes might be coming, because we have had changes, especially at the salary level, at least attempted, and in New York's situation, affected in the last couple of years. Not a resolved issue. In July of last year, the Department of Labor, under its new Commissioner of Labor appointed by President Trump, issued a request for information asking a bunch of questions about whether the current FLSA exemption rules should be changed, not only the salary requirements, but also potentially the duty requirements. A lot of interested parties commented. I actually submitted a 3,000 word response to those questions myself. If you really want to read it, I can get you a copy, but the gist of it was that I suggested that it was not a good idea for the FLSA exemption salary threshold to depend on geographic location, that states already can set their own requirements. So having separate federal levels in different parts of the country would just add to the nightmare for employers, especially those who have employees in different parts of the country, where they could end up with 2, 3, or more different salary requirements for the same type of work just based on where it's being done. Also suggested that the increase to the $913 a week was probably too high, and generally encouraged the Department of Labor to consider making the duties test easier to apply. So we don't know where they're going to go with that, but they're probably going to do something. They've indicated as much, that they recognize that $455 probably isn't a high enough requirement. But there is some uncertainty on the issue in Washington. There's plenty of uncertainty in Washington generally. There are even some reports that the Commissioner of Labor really has his eyes set on a different job, namely a federal judgeship. So, he might change, and that might change course. But as for now, they're getting information, and I imagine that there will be a new threshold, a new rule, may or may not affect the duties, etc. Whether that's proposed sometime in 2018 or later remains to be seen. I just wanted to quickly ask one final question. Thanks for hanging in there with me. Does anybody have any guesses as to whether the next salary level will be basically higher or lower than $700, which is about the midpoint between the current 455 and 913? Or is there anybody who thinks it'll be the 913 or higher? So if you just want to click one of those, nobody's going to know what you said and nobody's going to hold you to it. So most of you are saying between 700 and 913. There's a vote or two coming in for a little lower. So we'll see. My guess is it's going to be somewhere around that 700 number. I don't know which side of it exactly. I doubt we'll see the automatic increases as the last rule had, and we'll just have to see if they change the duties tests at all. The final point is, that might not matter so much in New York, because even a $700 or so level would not be as high as what's going to apply in New York, especially by the time any federal change would take effect. Again, there might be peculiar situations where the New York requirement is lower, for a professional employee, for example. But for the most part, New York employers are going to be more worried about what the state level is. I suspect the New York levels will go up beyond what's on this chart at some point in time. The upstate New York levels will eventually probably go higher than 937.50. Any increase in the federal level might only serve to further cause increases in New York. Like I said, the federal increases are probably going to be based, at least in part, on the average earnings in the southern part of the United States, where average earnings are much lower than the Northeast, and New York usually likes to be on the leading edge of employee protections. So I apologize for going a few minutes over, but I wanted to get a lot of this information out there. Just a second, I'm going to throw up the link to the slides, so you'll have those. But I'm also going to take questions. So if you have any questions, I know there's a lot to this, please type in your questions. I'll be more than happy to answer them. All right, so I'm going to throw up here, or you should have now, a link to take you to get the slides. Click I want the slides, and you should be able to download the PDF version of them. If you have any trouble, let me know. Again, hopefully you all see the chat and can ask questions if you have them. I'll certainly hang on a couple of minutes to see, give you a chance to enter your questions. One thing I'll note while we're waiting to see if there's any questions is on the New York increases that are scheduled over the next few years. In basically every situation, this is at least a 6% increase. So if you have exempt employees now who are currently making just around these levels, there is a good chance that the increase you'll need to make is going to be higher than what they would get otherwise, just based on the company's normal merit increases or what have you. There's a question here for FedEx drivers, and that's all the question says. I don't know if there was more to it. The FedEx drivers may be subject to that motor carrier exemption. Yeah, I think they probably do. I've never directly had to analyze FedEx drivers, but yeah, there's a good chance they'd be under that exemption. but you're right, that's it. So then you still have to satisfy the New York requirements because the federal motor carrier exemption isn't adopted at the state level probably. But there is a situation where the overtime rate is not time and a half the regular rate. It could be time and a half the basic New York minimum wage. So I suppose it's possible that an employer would say it's cheaper for us to pay overtime based on the time and a half minimum wage than it would be to exempt someone under. Yeah, right. I think you're making the point in the comments, but the trickier part about that is someone who's just a driver isn't going to be eligible for exemption under the New York rules anyway. But there are some other categories of employees, maybe higher up in the chain of command. Yep, that's a good question, and I should have mentioned it because I did say, what you don't know can hurt you. A lot of people don't understand all these intricacies of these exemptions, and the reason it's so important is if you get these exemptions wrong and you're challenged by the Department of Labor or in the courts by an individual employee or a class of employees, then the damages are that you'd have to go back and calculate the overtime that somebody should have gotten because they were improperly treated as exempt, for example, or if they weren't and just didn't get paid the overtime. But either way, so not only would you have to pay the time and a half overtime for however many hours over 40 that they worked, but if you treat them as exempt, you probably don't have the records to show how much they worked, in which case the employee's version of things is going to get a lot of weight. So they might say, oh, I always work 60 hours a week. So now you're talking 20 hours of overtime at time and a half, whatever the regular rate turns out to be. And then you might be calculating that under federal law back as much as 3 years in some cases, under state law as much as 6 years in some cases. Plus, once you calculate that, they're also entitled to additional liquidated damages. Basically, you double whatever the underpaid overtime was. So there's a potentially large amount of money there, even for one employee. But if it happens to be a huge group of employees, plus they can also recover their attorney's fees, which in many cases are much larger than the underpayment of overtime in the first place. So even a relatively small class action, say of 20 or so employees, if it's going back 6 years under state law and people are saying on average they work 10 hours more a week that they didn't get paid overtime for, could quickly cost hundreds of thousands of dollars, not even including your own attorney's fees. Question says, is there any timeline you've heard about on the issuance of a new federal proposed rule? No, at this point I haven't. Like I said, they had the request for information issued in July. There was a couple of months, I forget exactly, say the September timeframe that responses were due. They've had some time to consider it. Many of the top level positions in the Department of Labor that would have to consider new rules haven't even been filled, maybe even yet, or at least until recently. Like I said, some of those people may not be in their final position under the current administration. So I don't anticipate a new proposed rule coming out in the very near future. It could happen as early as this year, probably later in the year would be my guess as the earliest possibility. I mean, I could be surprised it could come sooner. But the current Commissioner of Labor, based on not only the request for information, but some other factors, seems to be really motivated to have a lot of information and evidence to back whatever he's going to do. So it'll probably take a while to compile that together into some new proposed rules. Just for those of you who aren't familiar with the federal rulemaking process, the Department of Labor would put out a proposed rule. They then have to allow time for public comment on the rule. So once they put it out, there'd be a few months for public comment. They would receive a tremendous amount of commentary on this type of rule, and then they would have to actually conduct some review of that commentary. They'll address it in basically a preamble to whatever final rule they put out. So it's going to take them a long time to put that together. That by way of saying there's probably little chance of a new rule taking effect this year, and there's no sure thing that it will take effect next year. The biggest indication of timing is really the length of the presidential term. The last rule took effect, or was supposed to take effect, essentially a month before, almost 2 months before President Obama left office. Reason to assume that the current administration, if they're serious about a new rule, would try to get it in place before the end of the president's current term, and ideally around, they would factor in the timing of the election preceding it. They probably wouldn't want to put the new rule out right before the election. They might do what the last administration did and have it take effect right after the election, or they might try to get it done well in advance of the election to minimize the political impact. So all that by way of saying probably any changes would take effect, say, between mid 2019 and early 2020 would be my best guess. Any other questions? Hopefully everybody was able to get the slide materials. If not, just let me know. Let me make sure I throw back up this slide with my information. If you need my email or phone number to contact me with any follow-up questions, here it is. If you have any trouble getting the materials, let me know. I'll give another minute for anybody to throw another question in there, but it looks like I've answered all of them so far. The presentation went a little over, and we've had some good questions. So thanks for those of you, most of you, who were able to extend your time today to stay through the end. I will wait about 15 or 20 more seconds. If nothing else pops up in the chat, then I will say goodbye and close it down. But I do hope you all found this to be helpful in learning in some detail about the differences between the federal and state exemptions and how they play off of each other and what your requirements are with respect to both. I think it's a good background knowledge for you to have, and hope you're able to put it to use now or in your future, in your career in the future. Seeing no more questions, I'm going to go ahead and say goodbye. Thanks for joining me, and until next time, take care.